Breaking news, this is Tiffany Heishman coming to you live from EFG News with an update about the Equal Employment Opposition Commission versus Abercrombie and Fitch Supreme Court case. As many of you know, the Supreme Court has been working to come to a decision regarding the EEOC versus Abercrombie and Fitch Supreme Court case. A decision has just been reached with the Supreme Court ruling in favor of the EEOC. The Supreme Court has been working to come to this decision since February 25th arguments heard by the Supreme Court. The Equal Employment Opportunity Commission versus Abercrombie and Fitch goes back to Abercrombie and Fitch's look policy. Abercrombie and Fitch's policy states that the store forbids black clothing and caps. However, they did not define cap in the look policy. The look policy got Abercrombie and Fitch in trouble when Samantha Ulliff applied for a job at Abercrombie and Fitch. Samantha is a practicing Muslim who wore a headscarf to her interview. Samantha did not mention that she needed accommodation for the look policy because she wore a headscarf, but neither did the interviewer. When Samantha didn't get hired because her appearance score was too low, Samantha believed she was being discriminated against because of her headscarf she wore because of her Muslim belief. The EEOC heard of this and decided to sue Abercrombie and Fitch. The Equal Employment Opportunity Commission stated that Abercrombie and Fitch went against the Title VII Act of the Civil Rights Act of 1964. According to Cornell law, this act prohibits a prospective employer from refusing to hire an applicant in order to avoid accommodating a religious practice that it could accommodate without hardship. The case went through a lot before it went to the Supreme Court, as the case first started in a district court. The district court ruled in favor of the EEOC. However, Abercrombie and Fitch was not satisfied with this and decided to appeal this decision in the U.S. Circuit Court of Appeals for the 10th District. The Circuit Court of Appeals ruled in favor of Abercrombie and Fitch on July 27, 2015. The Court of Appeals stated that Abercrombie and Fitch was not on sufficient notice of the need to accommodate the look policy because Samantha never stated that she needed accommodation, and Abercrombie only assumed correctly. However, the appeals court did state that the look policy did not clarify that headscarves were considered caps. The EEOC was not content with this ruling and decided to take it to the Supreme Court. This case was granted and listened to. Its arguments were listened to on February 25, 2015. The vote and decision was announced today, June 1, 2015, with the vote being 8-1, with the majority ruling in favor of the Equal Employment Opportunity Commission. Justice Thomas was the only justice to vote against the majority in this case. Throughout the entire case, Abercrombie and Fitch argued that an individual cannot say that they were being discriminated against without first telling the employer that they needed accommodation. However, the Supreme Court disagreed, saying that the individual only had to show their need for an accommodation was the reason they were not hired. More information on the Supreme Court decisions, including the majority decision statement, concurring opinions, dissenting opinions, will be given tomorrow at 8 by Chief Justice Roberts, Justice Silica, and Justice Thomas. We will also have an interview with Samantha tomorrow morning at 10. That's all for this breaking news update. Regular program will resume now. Signing off, Tiffany Heishman, EFG News.